14th District Court, County of Washtenaw, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge James Frederick Simpson presiding.
Good morning, Judge. Jen Wilburn, PA 83143 for plaintiff.
Good morning. Mr. Holliday? Yeah. All right. You're here. All right. What is plaintiff's claim in this case?
This is a non-payment of rent case, Your Honor. There's an outstanding rental balance, $1,567.93, plus court costs, $193, for a total of $1,760.93.
And sir, how are you intending on getting that paid?
My wife and I, well, I'm sorry, I'm a little intimidated by this. Yes, we should have the money by the end of the month, hopefully.
By the end of the month? All right. Have you tried to work something out with the landlord on that, sir?
They didn't really give me an opportunity to kind of work any kind of arrangement out. It's simply get us the money or we're going to court. I can tell you more about the circumstances. Make it a little bit more.
That I didn't know that at this point in time. What I'll do is I'll give you 1 week adjournment. See if you can work something. It's going to be 2 weeks. Oh, that's right. I happen to be out for other reasons on the 20th. So I have to go 2 weeks out, counsel, on the case, on his adjournment. So I will adjourn this matter. And sir, in the interim, see if you can work something out with the landlord. If not, then we'll deal with it on the 27th. I'll adjourn this matter June 27th, 2025 at 3 p.m. And sir, we played a video initially. If you need assistance, you should try to contact some of those numbers and see if somebody can help you out. All right?
Yes, I apologize. What was the date again?
June 27th at 3 p.m. That's an in-person hearing, sir.
An in-person hearing. Okay.
Yes, sir.
Thank you very much.
Okay. All right. Thank you.
Thank you, Judge. Have a good weekend.
Oh, you do the same.
Thank you.
Court does call the case of Beal Properties versus Lillian Martinez.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff. Your Honor, I believe we've submitted a proposed dismissal without prejudice for this case.
Oh, did you? Okay, I don't have it. This case has been dismissed. That is without prejudice. Court does call the case of Beal Properties versus Cozine Welch Jr.
Daniel Landman, appearing for the plaintiff.
Not signed in. They were here all morning yesterday.
They haven't signed in today, but we're here yesterday.
Yeah.
Okay. Yeah, it doesn't help us today. They're not here. If you'd like to take a default, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead, sir.
Your Honor, this is a summary proceedings action based upon a rental arrearage. Based upon my client's books and records, the current rent to retain is $2,030. Costs are $175 for a grand total of $2,205. The proposed default judgment would reflect a writ date of June 23rd. To the best of my knowledge, this tenant is not incompetent, a minor, or a member of the military service. And to the best of my knowledge, this lease premises has been kept reasonably fit for the use intended during the lease term.
Judgment to the plaintiff that is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days. Beal Properties versus Brielle Roundtree. I think it's supposed to be Roundtree.
Daniel Landman for the plaintiff.
Roundtree, they are not checked in. You may proceed, sir.
Thank you, Your Honor. Again, this is a non-payment action. Based upon my client's books and records, the current rent to retain is $1,774. Costs are $175 for a grand total of $1,949. The proposed judgment reflects a writ date of June 23rd. To the best of my knowledge, Ms. Roundtree is not incompetent, a minor, or a member of the military service. And to the best of my knowledge, this lease premises has been kept reasonably fit for the use intended during the lease term.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with a writ issue 10 days. Beal Properties versus Mike Lucas.
Daniel Landman appearing for the plaintiff. Mr. Lucas is present, Your Honor.
Yes, he is. All right. Mr. Lucas, good morning.
Good morning, Your Honor.
What is plaintiff's claim in this case?
Your Honor, this is also a non-payment action. My client's records reflect a balance owed of $2,244 and costs of $175 for a grand total of $2,419.
All right. Mr. Lucas, how are you intending on getting that paid, sir?
Well, my lease here ends on June 25th. And I already informed them that I was leaving. But prior to this, they received non-payment because of the deplorable conditions I'm living in. And I had to pack my stuff up, start taking it out of here to a storage unit because I got pictures, Your Honor, of rats in the garbage. I went without hot water for 8 days because they didn't want.
All right, Mr. Lucas, are you gonna move by that date? Because they're only looking for possession of the premises. Are you gonna move by the 25th?
I'm out of here.
Okay, that doesn't end. Are you out now?
I'll be out on the 25th. I told them yesterday.
Okay, all right, that works. Here's what I'll do. My next date is the 27th, so I'm gonna adjourn this to June 27th, 2025. At 3 p.m. And maybe at that time, the matter can be dismissed if you vacated the premises and turned in the keys.
All right. What's the date? What's the date, Your Honor?
June 27th, 2 weeks from today, 3
All right.
p.m. If you're not out of the premises, that's an in-person proceeding, so you'll need to be here.
All right, I'll be out of here, believe me. I'll be out of here before.
Okay, all right.
All right.
Thank you.
All right. Thank you.
Thank you, Your Honor. Have a great weekend.
You do the same, Mr. Lynn. James Convis versus Anna Teachworth.
Thank you, Your Honor. I'm asking for an eviction. I'm Jim Convis. I'm the owner.
Hold on,
landlord.
sir, state your name first of all, please.
James Convis.
All right. And your name, ma'am?
Anna Teachworth.
All right. It's a non-payment of rent case. What are you claiming is owed, sir?
Thank you, Your Honor. There may be more information here than you need, and I apologize for that, but I'm asking for an eviction order and a money judgment to be issued as soon as possible. To simplify this as much as possible, Anna has not paid any rent this year and hasn't even paid me back cash I loaned her last year. I have been telling Anna countless times this year that I have a court order to pay alimony to my ex-wife, and I am on a fixed income and cannot abide by that court order unless she starts paying rent. Many, many promises were made, but very, very, very few kept. No rent money has been made at all this year. Last year, she might have paid 2 months, and I was trying to work with her and some of her boyfriends so she could
Okay,
help.
sir, you are right. That is way too much information for right now.
Okay.
How much are you claiming is owed?
My demand letter is fine. It's $43.50. I don't expect to ever collect that, but that's fine.
Did you send a notice to quit, sir?
I did.
All right, there it is. $43.50. All right. Ma'am, first of all, do you believe that you owe that money? And if you do, when do you intend on paying it?
I do not owe the entire amount. I've asked for a detailed breakdown of what he claims that I owe $43.50 for, and I'm working with the Washtenaw County Housing and Michigan Department of Health and Human Services.
Okay, so you've applied to both of those?
I've applied to Washtenaw. I am in process of applying today to Michigan Department of Health and Human Services.
I got you. Okay, so here's what you need to do. Since you're applying for some type of assistance to pay, you would need to file in your packet. There was a rental assistance form.
Mhm.
You need to fill that form out. You need to put, when you do the DHHS, you need to put the tracking number on that. You need to file that with the court by next Wednesday.
Okay.
Okay. You say you contacted Hawk or Housing Access for Washtenaw County or SOS?
I did. I have to call and call back and schedule an intake now that I have the official paperwork.
Okay, so have you scheduled an intake with them?
Not at this time, no. I will call them today as well.
You need to get on that. I will adjourn this matter out. My next available date is the 27th. I'll adjourn it out to June 27th, 2025 at 12 noon. Folks, that is an in-person proceeding. Both of you need to be here.
Okay.
Your Honor.
All right? All right, thank you. That's it for us this block. Court stands in recess. You got the probably got it. All right.
The 14th District Court is now back in session. The Honorable Judge J. Cedric Simpson presiding.
And good morning. Yeah. Court does call the case of Arbor Woods versus Tanisha Booker.
Good morning, Your Honor. Rachel Northbush, Pallett's Law on behalf of the plaintiff. And
Hang on.
this one's actually a dismissal.
I don't.
Oh,
Hold on.
sorry.
Yeah, I see Ms. Dornbush. I didn't hear her.
Can you hear me now, Judge?
Yes, we can hear you. It was a problem on our end.
Okay.
All right. Yes, go ahead.
This one's actually a dismissal, Your Honor.
It is. Okay. Case is dismissed. That's without prejudice. Arbor Woods versus Jennifer Carroll and Linda Carroll.
I'm here.
Okay, I need a camera, please. All right, what is
Okay, hold
plaintiff's? All right, what is plaintiff's claim in this case?
With cost, Your Honor, $1,737.50.
All right, Ms. Carroll, how are you intending on getting that paid?
I can pay 700 today. I do have an SER in, to try and get help with the rest.
All right, so you're gonna pay $700 today?
Actually, can I do it tomorrow? I'm not sure. Maybe I'm gonna get a money order until.
Okay, that, you'll do that, and then you have an SER in?
Yes.
Okay, you'll need in your packet, or you can use the QR code that's on the screen. There's a form called a rental assistance form. You'll need to fill that out, put the tracking number on there, and file it with the court by this Wednesday.
Okay.
Okay, you need to do that. I do not have next week, so I will adjourn this then to June 27th, 2025 at 1 p.m. That is an in-person proceeding, ma'am.
Okay.
All right, thank you.
Thank you.
Arbor Woods versus Mary Clark.
She is not.
Mary Clark? Not present? Yes, you may raise your right hand, Ms. Douglas. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, for the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff. The rent to retain is $808.50. Costs are $186 for a total due of $994.50. We're asking for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Arbor Woods versus Melissa Cole. She is, okay, Ms. Cole is here. All right. And what is plaintiff's claim in this case?
With cost, Your Honor, $2,995.10.
And Ms. Cole, how are you intending on getting that paid?
I'm back to work. I was off work for like 2 months. And there has been some issues with my back pay. I'm still going through the stuff with that at my job, but I am back working full time. And my next full check will be on the 27th. I plan on paying as much as possible, which will probably be around at least $2,000. I did put in something. I applied to 2 places. One place I got denied. And then the other place, they said I needed an actual eviction notice, that they couldn't help me out right now because I didn't have an eviction notice. Like I said, I am.
So who told you that?
The DHS.
The last one.
The DHS.
Okay, that's not correct. If it was DHS.
It is. I have the letter that they sent, and they said it was denied because I didn't have an actual eviction notice.
Did you give them your paperwork?
I sent them the court documents. Yes, that was sent to my house, and they said that it wasn't an actual eviction notice.
Okay. Is Amy here?
Yes, she is. I'm talking to her.
Okay.
Good morning, Your Honor.
Good morning. I was trying to recall at the meeting, I think they were, when we ran into this, they were instructing individuals to go and to ask to speak to a supervisor, if I'm not mistaken.
I'd be happy to meet with her real quick and just try to clarify.
Okay, all right, we'll do that. So what I'll indicate is that you're gonna pay $2,000 by the 27th. Is that correct, ma'am?
Correct.
Can you pay that? What's the time on that? Time for 1? Can you get that paid, say, before noon on the 27th?
Yes.
You can? Okay, great. Then I'll indicate that, and then I'm going to adjourn this matter to the June 27th, 2025 at 1 p.m. Okay, get that paid before noon on that day. All right?
Okay.
The other thing is that if you resubmit your SER, there's the form that's in your packet, the rental assistance form. You'll need to fill that out, put the tracking number on, and file that with the court by Wednesday.
Gotcha.
Okay?
Okay.
All right.
All right. Thank you.
Yes, and Pam?
Yes.
Ms. Cole?
Yes.
Hold on the line. We're going to put you into a breakout room with our court liaison officer to try to clarify that issue for you, okay?
Okay, thank you.
Thank you. Arbor Woods versus Alexandra Figueroa Mejia. Figueroa Mejia. They are not here. Ms. Dornbush, you may proceed.
Thank you, Your Honor. There's rent to retain of $4,400 $406.54, cost of $186, for a total due of $4,592.54. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issued in 10 days. Arbor Woods versus Christopher Finkowitz. Christopher Finkowitz, they have not checked in. You may proceed.
Thank you, Your Honor. It looks like at this point, Mr. Finkowitz only owes a portion of the court costs, so the total balance due is $132.21. We'd ask for a default possession only judgment with writ to issue after 10 days, and in light of that balance, I assume the court will indicate no writ without hearing.
That is correct. Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days, no writ without a hearing. Arbor Woods versus Torrance Johnson. Torrance Johnson, you're not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,628.47, cost of $186, for a total due of $1,814.47. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days. Arbor Woods versus David McLeod. David McLeod, they've not checked in. You may proceed.
Thank you. There's rent to retain of $788, cost of $186, for a total due of $974. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Arbor Woods versus Tyrone Miller.
And that's a dismissal, Your Honor.
That's a dismissal. That case is dismissed. That's without prejudice. Court calls the case of Arbor Woods versus David Pitchford Jr. and Helen Cummings. Pitchford, Cummings.
I'm here.
response?
I'm trying to get.
I'm sorry.
I'm trying to get my camera on. Okay. Hello.
Oh, there you are. Okay. All right. You're Miss Cummings?
Yes, sir.
All right. What is plaintiff's claim in this case?
Your Honor, the remaining balance due is $296.83. It's about $55 in rent, and then the court cost of $242.
Okay, so $296.83.
That's correct.
All right. All right, Miss Cummings,
Yes, sir.
when are you going to get that paid?
Well, this is my case, Your Honor. They charged me late fees after telling me that they would dismiss my late fees. Then I end up with court costs. Now I'm on a fixed income. I pay my rent on time every month. I own my modular. And this time I ran into an error with the computer system. We're just now getting a site manager here. So no one's there at the office to help us with our problem. I've been here for 10 years. I was told to pay online. And the reason to have to pay online is so we don't have to pay a lot of court charges because they log it in late. But now here I am trying to pay online and it keeps coming up error. I go to the office. We don't have a site manager. I finally get someone. They tell me they're going to dismiss the charges. And then they didn't. I'm on a fixed income. I can't pay that. By the time I went in to pay what I thought they told me to pay, which was $750, it was at $11.77.17. I didn't have that. And you overcharge.
Okay, Miss Cummings. Miss Cummings.
Yes.
When you say you fell behind in your rent, they filed a case back in May.
I paid them in May.
And Your Honor, if I
Yes.
may, I'm reviewing the ledger, and it does look like my client did credit the May late fee of $55, leaving a balance due of $739.83, but that balance wasn't paid until May 21st, and at that point, this case had already been initiated. So there's the court costs of they're on the ledger for $244.15, but I think they're actually $242. So our balance makes that adjustment. It reduces it by $2.15, and then I do show the $750 paid on May 21st. There was an additional late fee on May 21st of $30. June charges hit, and there was a payment of $790.74. Looks like that was paid on June 7th. And so there was a June late fee of $55 that was charged as well on the rollover balance.
Got it.
And I'm on a fixed income. I can't pay.
Okay. All right, Miss Cummings. Miss Cummings.
Yeah.
If you had to get this paid, how do you think you can get it paid?
$1 down, $1 a month. I'm on a straight up fixed income, Judge Simmons. I don't have extra money.
Ma'am, Miss Cummings.
Yes.
Miss Cummings.
Yes.
I hear you.
Okay.
Okay. The reason I was asking the questions that I was asking is because if I didn't think that you owed it, I would say so. But it sounds like it's owed. So the question becomes, and that the case was properly initiated. So then the question becomes for me as to how you can get this paid.
I have to pay a little bit at a time. I don't have money.
Pardon?
Your Honor, if the court wants to set this over for the next date, I can certainly talk to my client and see if they're able to work out any sort of payment plan with Ms. Cummings with respect to the balance. I don't have any authority to do that today, but I can certainly inquire with my client.
All right. You understand that, Ms. Cummings?
I sure do.
All right. So here's what I'm going to do, Ms. Cummings, is I'm going to adjourn this to June 27th, 2025 at 1 p.m. Okay. In the interim, Ms. Dornbush is going to talk to her client, see if there can be a payment plan to try to make this manageable for you. It's just that you ended up with the court cost, and that's really what the problem is here. So we could figure this out. Don't lose hope. We'll get it done. Okay.
Okay.
All right. We'll see you. That's an in-person.
I got a
hearing on that.
question.
Yes,
Do
ma'am.
they keep adding late charges when you don't pay? So does it stop here?
Okay. All right, Ms. Cummings. Ms.
Yes.
Cummings.
Yes.
Hang on. We'll figure that piece out for any late fees that come later in the month. But let's try to figure out if this were the amount, how we're going to get that paid. And let's try to work out a payment plan, and then we'll figure out the late fee part after that. Okay. So let's take it one step at a time. All right.
All right. Okay.
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 So I'll set it out on the 27th at 1 p.m. That's an in-person hearing. Okay, Ms. Cummings?
I'll be here. I'll be there.
All right. Thank you, ma'am.
Thank you.
Arbor Woods versus Heather Randall.
I'm here.
Oh, there she is. All right. All right. What is the plaintiff's claim in this case?
With cost, Your Honor, $3,889.75.
Okay, Ms. Randall, how are you intending on getting that paid?
I just got back to work. I've been in the hospital. I had surgery and then had to subsequently go back in. So I'm back to work starting Monday full time. So 2 weeks from then, I can make a payment of at least $1,200, and then I'll have to see, the dates on the rest so I can figure out. I do get paid weekly.
Okay. All right. So hold on there for a moment. When's the next time you think you can make a payment of at least $1,200?
Next Friday.
On the 20th?
Yes.
Okay.
So it would be Saturday.
Right. Gotcha. So and by the 27th, can you make another payment or no?
Yes.
You get paid weekly.
Yes,
All
I
right.
get paid weekly.
How much would that be, you think?
600.
600? All right.
Yes.
Okay. So here's what I'll do. Have you reached out for assistance at all, ma'am?
Like I said, I just got out of the hospital, and I just got all of this paperwork. So I will be filing for a state emergency relief and looking into other things, looking into other avenues.
All right, let's do this then. You look at making those payments. I will adjourn this to June 27th, 2025 at 1 p.m. And then what I'm going to do, did you see the video and do you have the numbers and things like that, or?
Yes, I saw the video.
Okay, so what we'll do is let me also, since you just got out and to try to make sure things stay on track, you still make those payments. I'm going to put you into a breakout room with our court liaison officer.
Okay.
And talk about what might be available for you. Okay.
Okay. Thank you so much.
Try to get you back on track.
Thank you.
Okay. All right. We'll see you in a couple weeks. Thank you.
Thank you.
Court calls the case of Arbor Woods versus, you're going to put her in the thing. Okay. Court calls the case of Arbor Woods versus Erwin Robertson.
And that's a dismissal, Your Honor.
That's a dismissal. You made me stumble over the name and then, okay, that's okay.
Sorry.
All right. That case is dismissed without prejudice. Arbor Woods versus Damon Stafford. And also Vansari Polk. Stafford, Polk, not here. You may proceed.
Thank you, Your Honor. Mr. Stafford did reach out to our office this morning, Your Honor. He indicated that he thought court was yesterday and that he is traveling today. He indicated he was going to try to get onto the Zoom call today, but he didn't specifically know when his plane was departing or if that would interfere. I let him know that if he wasn't able to sign onto Zoom, I'd have to request the default judgment. He indicated, Your Honor, his intent to have everything paid on June 25th. The statutory 10-day period is June 23rd, and I let him know that. And I did also let him know that he could reach out to Arbor Woods directly to see if they would hold off on seeking the writ until after June 25th.
Okay.
So for that, I do have to request the default judgment, and there is rent to retain of $1,483.73, cost of $242 for a total of $1,725.73.
What I'm going to do in this case, and thank you for informing the court in your candor, I'm going to grant a judgment for possession to the plaintiff with the redemption amount in the amount requested. I will do this since they reached out and he indicated a specific date, and I don't think it's going to cause any harm. A writ issued the 25th. I'll do it that way, and I realize I'm doing that over the objection of plaintiff.
Thank you, Your Honor.
Court does call the case of Arbor Woods versus Carol Toronto and Judith Wells.
So here. Oh, I'm here.
Okay, hello, Ms. Wells. All right. What is plaintiff's claim?
With cost, Your Honor, $3,481.44.
All right. Ms. Wells?
Your Honor, if I would be allowed to speak for Miss Welts, I'm Carol Taranto's daughter.
I'm sorry?
I'm Allison Kirby. Sorry. I was wondering if I would be allowed to speak for Miss Welts and Carol Taranto. I'm their daughter and granddaughter, respectively.
Okay. So you're the daughter and
I'm Carol
granddaughter.
Taranto's daughter and Judy Welts' granddaughter. Yes.
Okay. Okay. Normally I'll let you go ahead. All right. What do you want to say?
Thank you. I really appreciate that, Your Honor. I would like to request a motion for continuance. If possible, Carol Taranto is the primary provider and therefore has more of an idea of the finances, but she's currently in the hospital. So I was hoping if we could push this case until she was released.
All right. So let me ask this before I do anything. Is there any amount that can be paid within the next couple weeks? Do you know?
I don't currently know the state of her finances, unless that was something that I would be paying. But yes, that I'm unaware of that. I'm sorry.
All right, Ms. Wells, you don't have any idea as to whether something can be paid or not?
No, I don't know, Your Honor.
Okay. Okay. Here's what I'll do. I will adjourn the matter to the 27th, 2025 at 1 p.m. That's an in-person proceeding. Are they going to potentially be in need of any assistance, ma'am, do you think, or?
I'm sorry, I'm sitting with Judith here. We are currently having a very hard time.
Who are you?
I'm sorry.
I'm sorry.
I'm so sorry. I'm just helping Judith in person. My name is Anna. I'm one of her granddaughters.
Okay, so I got granddaughters and all over the place here. All right, go ahead.
Yeah, so one has been coordinating getting the hospital to like fax documents over, I guess, and then I'm the one that is in person with Judith.
Okay.
But I am seeking resources for her for all of the above, like any type of state assistance, anything that we can be directed to, we would appreciate.
All right. So here's if they seek assistance through DHHS or anything along those lines, or any other type of assistance, in the packet, there is what's called the rental assistance form, the packet that was served on them. That would need to be filled out with, and if it's DHHS or a state emergency relief, there's a tracking number that would have to be put on that form. All right. If there's any other type of assistance, that would have to be listed out. And then that form needs to be filed with the court by Wednesday. Okay.
Oh, I'm sorry.
Okay, I got it, Grandma.
Okay.
You got that? Okay. And here's what I will do also. She's just going to be busy today. Let me have the two things here. It will put you in with my court liaison officer, and they may be able to apprise you of other assistance that might be available. Okay?
Yeah. Thank you so much, Your Honor.
Thank you. So that's on the 27th. That's an in-person hearing. All right. But we'll go from there on that. All right.
Thank you,
Yes,
Your
hold
Honor.
on. Pardon? Who's the last name?
The one with Judith Wells, the granddaughter.
Oh, the granddaughter that's with Judith Wells. For our records, we need your last name.
Jones.
I told you it was really easy. No, I'm kidding. All right. All right. Well, so you guys hang on the line. We'll put you into a breakout room with Amy, and she'll be able to discuss some things with you. Okay?
Yes. Thank you so much, Your Honor.
Yes.
Thank you. Arbor Woods versus Roy Williams.
There's a second tenant.
Oh, I'm sorry. And Terry Williams. Roy or Terry Williams? Not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $785.24. cost of $242 for a total due of $1,027.27. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ to issue 10 days. Northfield Estates versus MLO.
Hello,
Hello, Ms. Lowe. How are you?
I'm okay. How are you?
I think I'm okay. All right.
I feel
And
excited.
what
I've
is,
seen you on court cam before. I feel like I'm talking to a celebrity.
yes, Miss Dornbush is a celebrity. All right. All right. What is plaintiff's claim in this case?
With cost, Your Honor, $1,438.65.
All right. All right. Ms. Lowe, how are you intending on getting that paid?
I just got my first paycheck at my new job today, so I was gonna pay 800 of that, and then before my next paycheck, should be able to come up with the rest of that balance.
Okay, so you're going to pay 800 today?
Yep.
Okay. And
Your
then
Honor,
there's
just to clarify, my client reported that Ms. Lowe already paid 800 today, so is she going to pay another 800 then?
Correct. This was my first paycheck at my new job. I lost 2 jobs in 3 months, but I have 2 new jobs, so I'm hustling, trying to get that money paid.
Gotcha. Okay, I just wanted to clarify, Ms. Lowe, because I knew you had made the one. So
okay,
Yep.
so you already paid the 800.
I paid an 800 this morning. I have another 800 coming tonight.
Okay, so there's going to be a total of 1,600 that's paid.
By Monday, when they get the after hours.
Okay. All right. So if you do that, what will likely happen, I'll give you an adjourn date of the 27th, 2025 at 1 p.m. But that will look like that will take care of everything. And so that's paid, the case would be dismissed, or am I wrong?
no, the 1438.65, Your Honor, already takes into account the $800 payment made this morning.
I got you. That makes sense. I'm sorry. Okay. So you're going to pay the 800. I'll adjourn it out to the 27th at 1 p.m.
If I have that balance.
Make that.
Thank you,
Okay.
sir.
And so when's your next check?
It's 2 weeks from today.
So on the 27th?
Yep.
Okay. So do you think you can get something paid if it's going to be the balance before, say, noon on that day?
If it's paid total by balance, does that mean I don't have to show up in person?
What, you don't want to be there in the presence of a celebrity?
I
What's the
do, but
deal?
I just
No.
don't want to miss any more work. Just starting at my new job.
Ma'am, if everything gets paid prior to the court date, they would dismiss it.
Oh, thank goodness. Thank you so much. Yes,
All
that will
right.
be done.
So, all right, then I'll set it on the 27th at 1 o'clock. Ms. Lowe, you have a great
so
weekend.
much. You too.
All right. Take care.
Bye.
All right. That's all I have for you, Ms. Dornbush.
I agree, Your Honor. There are a couple people though signed into Zoom.
I
don't
know.
if they're Arbor Woods tenants. They might be dismissals. But before I signed off, I just wanted to make sure I wasn't missing anything.
And they all disappeared except the phone, but I don't have the number.
Yeah.
There is an individual who has called in. I don't have the number up anymore.
Hi. Hello.
Hello, what's your name?
Kimberly Clayton.
That one is a dismissal, Your Honor.
That was a dismissal? Okay. Your case has been dismissed, ma'am.
Okay. Thank you. Have a good morning.
All right, you too. Thank you.
Thank you.
And I don't have anybody else on there, Mr. So, court calls the case of Arbor Meadows versus May Hall.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Have her or no?
Ms. Hall?
Yeah.
No, I'm sorry. She's not checking.
May Hall, also known as Lucille Hall. No response. Would you like to take the call?
Yes, Your Honor.
Raise your right hand to be sworn.
There is a consent judgment, Your Honor, but the defendant has not appeared. We submitted it, she signed it, but she was informed she needed to be here to place her consent on the record. If the court is willing to take the consent judgment as presented.
I can't.
I understand.
Anyway, raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, help you God.
I do.
Go ahead.
Thank you, Your Honor. This is a termination of a tenancy case at a manufactured housing community. Defendant was provided with notice at the first hearing. Of the second hearing, the defendant has several outstanding violations for correcting the exterior of the home. The corrections have not been made since the filing, and we'd ask that the court issue a default judgment with a writ date of June 23rd, 2025.
Judgment to the plaintiff, that is by default.
Thank you, Your Honor.
Possession, no redemption amount, writ to issue as indicated in the judgment. So what I've done, so the record's clear, is I've taken the consent judgment, entered it as a default, and I signed it.
Thank you, Your Honor.
Court does call the case of Arbor Meadows versus Maria Herrera.
Good morning, Your Honor. Michael Burns, P 87855 on behalf of plaintiff.
All right, you've been sworn. I see that this is the same type of circumstance. You may proceed.
Thank you, Your Honor. We asked for a default judgment, similar circumstances. The previous case of determination of tenancy for failure to remediate issues on the exterior of their mobile home. No money judgment entered. We'd asked for a writ date of June 23rd, 2025.
Judgment to the plaintiff by default for possession. No redemption amount, writ to issue the 23rd. Arbor Meadows versus Jaywin Root.
Your Honor?
Yes.
I just spoke with Ms. Robin Root. Who's Root one come up?
I see Jaden Robin Root.
Mr. Javin Root is deceased.
Okay.
We have not entered an appearance in this case, but Ms. Root did reach out to me asking me to review this consent judgment that was signed, and I did review it for her, and I had some concerns about it that we wanted to bring forward. I was hoping to talk to counsel before the case was called to see if we.
I'll pass it.
Thank you, Your Honor.
Court calls case of Esquires versus Christine Good.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff, Mr. Dennis Pappas, who stands to my right.
And Pat Clappers. Christine Griffin, no response. You've been sworn. You may proceed.
Thank you, Your Honor. We'd request a default judgment, possession only, no money judgment to enter. There's a rent to retain of $3,420, costs in the total of $175.69 for a total of $3,595.69. And we'd ask for a writ date of June 23rd, 2025.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ issue.
Thank you, Your Honor.
Thank you. All right. And let me know when you're ready on that other one. Augusta Woods versus Anthony Wilson. That matters discussed on plaintiff's motion. Court calls the case of Arbor Manor versus Patrick Brooks.
Thank you, Honor. Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Hey, Chair. Patrick Brooks?
Yes.
All right, there you are. All right. Where are we on this case?
Thank you, Honor. This case was adjourned. As you will recall, there were repairs that were made to a pipe behind the wall. The defendant has failed to pay rent, even though the repairs had been made. He was not giving access to the landlord to do the drywall repairs, and you told him to do that. He did provide access, and the drywall repairs have been made. The amount of rent due is $2,957. The last payment he made was in February, for $101. Court cost of $178 for a total of $3,132.
Repeat that number for me.
$3,135.
All right. Mr. Brooks?
Yes, sir.
The repairs have been made?
Yes, they just finished the drywall last night, but they have a couple more things to work on, which I'm not that concerned with. I was really concerned about the drywall because that was the main thing.
Okay. And so when is the rent going to be paid, sir?
I just need a little time. And a question I have, so even though I wasn't able to stay there for the past couple months, I can't be compensated in any kind of way for that.
The drywall repairs were behind the toilet. They had no effect on the habitability of the unit.
No, but they had to fix the drywall because the pipe was cracked, so I wasn't able to flush the toilet due to the fact I wasn't able to stay there because I couldn't use the bathroom.
I understand they made the repairs promptly, but couldn't finish the drywall because access wasn't provided.
All right. Well, I had requested or had ordered a written answer to the complaint, did not get a written answer to the complaint. But, you know, if you're disputing the amount that's owed, then I'll sort it out. I'm going to set this matter for non-jury trial for July 1st, 2025, 9 a.m. That is in person for both parties. And that's a Tuesday. So we'll hear everything and then I'll render my decision.
Thank you, Honor.
Thank you. Court does call the case of Sycamore Meadows.
Judge, could I get a breakout room with Mr. Brooks in the meantime? And then
Mr. Brooks, do you want to meet in the breakout room with him?
Sure.
All right, yeah, we'll put you into a breakout.
Thanks, Judge. Have a good-
Sycamore Meadows versus Tabria Story.
Good afternoon, Your Honor. Attorney Carrie Zanon, P67390 on behalf of plaintiff.
Good afternoon, Emily Wilkie, 88273.
All right. Where
Judge,
are we on this case?
This started with us being in front of you because of an order of eviction. So, Judge, I'm withdrawing the writ at this time.
All right. We'll indicate that the writ is withdrawn.
Thank you.
Could you potentially indicate that the judgment amount has been satisfied?
Pardon?
I can't do that at this time. I don't have that documentation to show that, but I'm sure that it is. And give me a week and if I can get it done, I'll get it done.
Thank you. Sycamore Meadows versus Tarad LaFleur.
Again, Carrie Zanon on behalf of plaintiff, Your Honor.
Your Honor, I believe Ms. Lee was going to appear on this.
Is that who you were talking to? Ms. Lee?
I haven't spoken to anyone today. I was supposed to meet someone today, but I haven't spoken to anyone today.
I do believe that,
Pass it. Have a seat. Sycamore Meadows versus Erica Jimerson.
And Carrie Zanon on behalf of plaintiff, Your Honor.
What?
I believe Ms. Lee is also.
Then I'll deal with it. I passed it. I guess Ms. Lee is dealing with it. So as soon as they get back in here and she graces us again with her presence, I'll call. All right.
Okay, Judge. I don't believe I have an appearance for either, but on either file yet. So.
Yeah, I know. I never do, which is really irritating, but I understand your frustration.
Thank you, Judge.
Avalon Housing versus Yolanda Shepherd.
Good afternoon, Your Honor. Jillian Engen for plaintiff.
Good afternoon, Your Honor. Andrew Campbell, on behalf of the defendant. We have talked, Judge. I believe opposing counsel wants additional time, and I have no objection to that to respond to the motion. Oh, sorry. My client is here as well, Judge. We have no objection. We're still trying to work out a settlement.
I thought we were resolved.
We were trying to resolve. I believe there's.
What's the hang up?
Your Honor, so Ms. Shepherd is first in line for new housing. I think that once she has new housing in surrender's possession, I think that this case will be moot, and so we'll be able to hopefully dismiss it at that point. And Your Honor, I also, I don't know if Your Honor, has Your Honor signed the order that was submitted under stipulation? I don't know that we have a copy.
Right, that's correct, Judge.
The order prohibiting occupancy. And on June 4th. I just signed it.
Your Honor.
Yeah, and that's, Judge, just for the record, that's not a final order because we still have.
I understand that.
Okay, I just want to clear, Your Honor, I'm sorry. And did you want a deadline?
Your Honor, could you adjourn this for 2 weeks? We will respond to the motion for summary disposition by the 25th. I think that's the 21 days since it was served. And then I think Mr. Campbell also asked for a reply to the answer. And so we will have that submitted as well by the 25th.
I'll set this for the motion, for hearing on the motion, and yeah, I'll just set it for that at this point. July 1st, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case people of Evergreen Apartments versus Kayla Smith.
Plaintiff.
Hello.
Hello,
What's your name?
Kayla Smith.
All right. Where are we on this?
Your Honor, Ms. Smith has brought balance down to $516.41 inclusive of costs.
How much?
$516.41.
No. No, I know. I know.
And Your Honor, DHHS is paying the remainder, so
They're gonna be-
we need extra
okay.
time for them to get that paid. I think a week should do it because they were supposed to submit payment on the.
Okay, my next available date is the 27th. So what I'll do is I'll adjourn it to June 27th, 2025 at 2 p.m. That's an in-person hearing, but if everything's paid, you're good.
So I don't have to come if everything's paid?
Don't look at it like that's a favor. You don't want to come see me? Is that,
I mean,
no,
I like
that,
you,
no, no, that's
but
okay. That's
childcare is hard
no,
to
it hurt.
Okay, 26.
Answer your question now. If everything's paid, you don't have to show.
Okay. good.
Okay,
Thank you.
just double check it. You may want to call.
Verify with Sydney.
Okay,
Sydney
okay.
will keep you updated.
Okay.
All right, you have a
Right.
great weekend.
Thanks, you too.
Flomar Apartments versus Caden Duford.
Jillian Engen, plaintiff.
You got him in all.
And we did check it.
Caden Duford, Can you check that? Huh? Yeah.
And Your Honor, just so you know, we are requesting leave to amend. There was a 1 month notice to quit sent. And so.
Got it.
Requesting leave to amend.
No. No answer. You're sure he was here? Yeah. And you're sure they were here?
Someone answered yes when I called Kate and Newford.
All right, let me pass it.
Thank you.
Glencoe Hills versus Tillman McCommons.
Jillian Aiken for plaintiff.
Also checked in.
Hello. Hello, sir. Yeah. Your name?
Tillman McCommons?
All right, this is your motion to set aside the judgment?
Yes.
What's the basis for the motion to set aside, sir?
I was here last time. That French, he gave me the wrong time for my appointment. Then he left and
Got it.
and went into default.
Okay. This was the one in
Yeah.
okay. So apparently there was a time that issue. He was here, but his time was wrong. So I'm going to grant his motion to set aside.
I believe, Your Honor, that we have filed a writ, and so we can withdraw that.
Yes, and the writ's withdrawn. All right, and balance is what at this point?
I have a balance, including court costs, Your Honor, let's verify this, of $4,373.71.
All right. And sir, how are you intending on getting that paid?
Well, I can pay today. I got like 1,300.
All right. Have you tried to work something out with the landlord regarding?
I've been corresponding back and forth with her about that, and I talked to her last time. She said my judgment was like 1660.
Well, your judgment was 2888.15. I set that judgment aside. That was from May.
Okay, and then I came in to pay the motion. I paid like 1,200 for the motion.
You put 1,200 in?
Yes.
You certainly did, sir. You put $1,254 in, and you have how much today?
1,200.
Gonna bring it down below 3,000.
Right. And are you working with Hawk at all?
I got denied.
Okay. All right, let's do this. I'm going to release the escrow to the plaintiff. Okay, so what you put in, I'm going to order it released to your landlord.
Okay.
Okay. You have 1,200. I want you to pay the 1,200 today to the landlord also. Okay.
Okay.
And then what I'll do is I'll adjourn this out to June 27th, 2025 at 2 p.m. to figure out how we're going to deal with the rest of the balance.
Okay.
Okay?
Yes, sir.
All right. Thank you, sir. Court does call the case of Glencoe Hills versus Devonta Jackson. And LaChina Williams. They did ask for what?
To appear Zoom. I don't have either individual.
Devonta Jackson, LaChina Williams. Neither are here. Would you like to take it to call?
No, I'm here.
Oh, you're here. Okay, your iPad. She usually has her name on. All right, go ahead. Okay, folks, I need to move this docket.
Sorry, Your Honor. Jillian Aiken.
All right, this is LaChina Williams.
Mhm.
She's here and didn't even credit me for getting her name right. No, I'm not going to say anything. Don't worry about it. Everybody's been hurting my feelings today. All right. How much do we have owing on that? It might be under Devonta Jackson.
I see it. Okay. That's fine. I have a balance including court costs of $3,031.61. I have an update from my client that Hawk is that they are currently on a waiting list for funding. They're hoping they can make a request soon, and they will reach out when they have more funding and can submit the request.
Okay. but we don't have an idea as to when that's going to
Exactly,
happen.
right.
So are they thinking that it's even going to be before the end of the month, or? You don't know.
No, sorry.
All right. Well,
Your Honor,
yes.
if, maybe if the defendants could put some funds into escrow with the court, then it wouldn't necessarily, if they, I think, I mean, they're over $3,000 right now.
Right.
Get that paid down and then any extra put.
Ms. Williams?
Yes, I plan to pay it down as much as I can, but I know I won't be able to pay the whole balance. That's why I was just going to wait on halt.
Okay.
Because I know July charges are going to come in effect as well soon.
Yes. So let me ask you this. If I ordered you to pay funds into court escrow, how much do you think you can pay?
I could pay $400.
Okay. So let's do this. Give it a chance to try to figure it out. Pay $400 to court escrow. All right. And that means you come down with cash to the court, put it in there. Okay.
Okay.
And so get that in, and then I'll adjourn this out to my next date, the 27th, 2025 at 2 p.m. And then we'll see exactly where we are. I may have to issue a judgment at that time, but at least we'll know for sure where we are. Okay.
Okay. Thank you.
Thank you. Court calls the case in Hamilton Crossing 1 versus Victoria Bolt. Hello.
Hello.
What's your name?
Victoria Bolton.
Thank you. All right. And where are we on her case?
I have a balance including court costs of $2,237.
All right.
And I made a payment last week as well, and I plan on making one today.
Last week of $300?
Yeah.
Okay, I see that on the ledger.
Okay, was that taken into account?
Yes, Your Honor.
Okay. You said you plan on making another payment?
Yeah, but I feel comfortable putting in escrow right now.
Pardon?
I feel more comfortable putting it in escrow through the court versus giving it to them.
Why?
Because I just have a lot of pending work orders that's from like January. They don't really like repair anything. They told us if it's not an emergency.
So you're gonna put it into escrow?
Well, today I'm gonna do 300.
All right, you need to put $300 into escrow. You need to give a written list to the landlord of those repairs. Okay, that you're saying that are going to be needed.
Okay.
And you're to do that by this Wednesday, the 18th,
Okay.
with a copy of that list to the court.
Okay.
And then I'll adjourn this matter to June 27th, 2025, 2 p.m.
Okay. Thank you.
Thank you. Hamilton Crossing 2 versus Ashley Jordan.
Jillian Ingham for plaintiff.
Ashley Jordan.
I think she did.
She went where?
She's talking with legal services.
Okay. Hello. Your name?
Ashley Jordan.
Determination.
Yes, Your Honor.
I have not had a chance to speak with Ms. Engen yet, but I just spoke with Ms. Jordan, and we had spoken before about her situation. And I'm willing to enter an appearance in this case, but I'm hoping that we can work it out with Hamilton Crossing.
Will indicate here that legal services is going to enter an appearance. And what I will do is I'll adjourn this out June 27th, 2025, 2 p.m.
Thank you, Don.
Thank you, Your Honor.
Thank you. Hamilton Crossing versus Jessica Jackson. Hamilton Crossing.
Jillian Ingham for plaintiff.
Hello.
Hi.
Your name?
Jessica Jackson.
All right. What's plaintiff's claim in this case?
I have a balance including court costs of $1,118.
All right. So she got that $1,000 in. How are you going to get the rest?
I have a money order in my car for $500.
You have a money order in your car?
Yes.
Why'd you leave it in your car? No, never mind. Nah, okay. I don't.
'Cause I had
You
just,
got 500 in the car.
yeah, because I had just got paid and I didn't want to be late for court. So,
You didn't want to be late for court?
No.
Oh,
so
Valid.
that's
Valid.
that's nice. That's nice of you. Okay, so you have 500. Then how long is it going to take to get the rest of that? You got about another
I have to pay Friday. Next Friday.
the 20th next Friday or the 27th?
What's that?
Today's the 13th. So 2 Fridays from now would be the 27th, and
18th.
next Friday's the 20th.
20th.
You'll have it paid by the 20th?
Yes.
All right, so what I'm gonna put in here, you pay $500 to the landlord today. All right, and then I'm gonna mark that you're gonna pay the balance by the 20th. I'll adjourn this matter to June 26, 2025 at 2 p.m. If you've got everything paid, I don't need to see it, not that I wouldn't want to. Okay, before you hurt my feelings and say you don't wanna come see me, all right?
Okay, thank you.
I'm sorry, it's the 27th then.
27th?
Yeah, next Friday. All right, or 2 weeks from now. Court calls the case of Hamilton Crossing 2 versus Jeffrey Williams.
Jillian Ingham for plaintiff.
And hello.
Shirley. I'm Shirley Williams.
All right. And what's the claim now?
I have a balance including court costs of $811.
All right. How are we gonna get that paid?
On the 20th, I'll be paid.
You can pay it all on the 20th?
Mhm.
All right, then I'm gonna put, you're gonna pay 811 on the 20th. I'll adjourn this out to June 27th, 2026, or 25. I don't know why I wanted to say, I don't know why. At 2 p.m., okay?
Thank you.
And if you're paid, I don't need to see it.
Okay.
All right. Here, let me break in here real quick and try to get Ms. Zane in now. I think they said they're ready. Are you ready on the Sycamore Meadows cases? Sycamore Meadows versus Erica Jimerson.
Again, Carrie Zanon on behalf of plaintiff, Your Honor.
Emily Brooke, Emily Brooke, the AHG.
All right. All right.
Judge, we
What are
are
we doing
working
on
to
this
resolve
case?
this. We are trying to work to resolve this. Can we adjourn this to the June 27th date?
Any objection? Case is adjourned June 27th, 2025. What time is it? At 3 p.m.
Thank you, Judge.
Thank you. Sycamore Meadows versus Tyrod LaFleur.
Again, Carrie Zanon on behalf of plaintiff.
Again, Emily Brooke.
All right. What do we want to do? Hello, Miss.
Judge, the same thing as the previous. Can we adjourn this to June 27th?
All right. All right, Mr. LaFleur, I'm going to adjourn your case out to June 27th, 2025, 3 p.m. Okay. All right. Thank you, sir.
Thank you, Your Honor. Have a wonderful weekend. Happy Father's Day.
You do the same. Were you ready? Court recalls case of Arbor Meadows versus Jaden Ruth. Jake Mooney.
Good afternoon again, Your Honor. Michael Burns, P8 7855 on behalf of plaintiff.
Good afternoon, Your Honor. Officially, I will be entering my
Robin Root.
with Ms. Root. And I believe counsel and I have agreed that we are going to submit a new conditional order of dismissal in this case with some additional protections for the defendant in that she will be required to maintain the home site in accordance with rules and regulations of the park for 12 months until June 10th, 2026. But if plaintiff alleges that there has been a violation of those rules and regulations, they will notify us as counsel and Ms. Root and give us an opportunity to respond and object and have a hearing.
Is that basically it, counsel?
That's correct, Your Honor.
Are you guys going to put that together? And
I'm going to draft a conditional order of dismissal this afternoon, Your Honor.
all right. Then I'll adjourn this out to June 27th, 2025 at 3 p.m. If you guys have that, then I can enter it if they're both sides are represented by counsel.
Thank you, Your Honor.
Thank you. Court calls case of Huron Vista Apartments versus Sabria Williams.
Andrew Campbell on behalf of the defendant, Your Honor. I believe we needed a ledger, and Ms. Ingen is going to give me one today, Your Honor, so that we can have time, so we can get an updated amount and get that paid, Judge. So I believe opposing counsels will consent to an adjournment of 2 weeks.
Yes, Your Honor, we're happy to adjourn. And for the record, the court, the total balance, including court costs, is $478.
478. June 27th, 2025.
Thank you, Judge.
2 p.m.
Thank you.
Thank you. Court does call the case of Huron Vista versus Alicia Moore.
Jillian Ingham for plaintiff.
Alicia Moore? Not checked in. Would you like to take it to vote?
Yes, please, Your
All
Honor.
right, I don't think I've sworn you in. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Go ahead.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $4,485, court cost of $176, for a total of $4,661. Plaintiff is requesting a default judgment for possession only with a writ to issue after July 5th.
July 5th.
2025, Your Honor. We're going to set this aside if if Ms. Moore pays $1,661 on or before July 5th, then we will set this judgment aside.
Gotcha. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ to issue as indicated July 5th.
Sorry.
Court does call the case of here on Vista versus Jacqueline Taylor.
Jillian Engen for plaintiff.
Hello.
Jacqueline Taylor?
Good afternoon.
Okay, she's here. Your name, please?
Jacqueline Taylor.
Thank you. All right, where are we on?
Your Honor, I have a balance including court costs of $2,413.03. I believe that we are looking to enter, I believe that Ms. Taylor is participating in the forgiveness plan.
Okay.
We'll be drafting a conditional order of dismissal.
All right, is that correct, ma'am?
Yes.
All right, do you want me to adjourn this out?
Please, Your Honor, to the 27th.
Okay, ma'am, I'll adjourn your case to June 27th, 2025 at 2 p.m. All right?
Yes, sir.
All right, and hopefully we'll have everything all resolved by then. All right, take care.
Okay. Thank you. You as well.
Court does call the case of here on Vista Apartments versus Danielle Davis.
Jillian Engen for plaintiff.
Danielle Davis has not checked in. You may proceed.
Your Honor, I believe that this is a motion hearing.
This is a motion to set aside default. Danielle Davis, defendant having failed to appear. Motion to set aside is denied.
Your Honor, may I ask, is there escrow in this matter?
Yes, we have $500 in escrow.
Okay,
So escrow to plaintiff.
thank you, Your Honor.
Court calls the case of New Park Ridge Apartments versus Alana Armstead.
Jillian Engen for plaintiff.
Hello.
Hello, Ms. Armstead. How are you?
I'm good, sir.
Good. All right, where are we on this case?
I have a balance including costs of $1,575. Ms. Armstead and I did discuss briefly this matter. She's going to make another payment of $300. Is that correct?
Yeah.
And then she's getting assistance.
The Breeze program through Michigan Works.
Through what?
The Breeze program through Michigan Works
Okay. So she's when are you gonna pay the 300?
today.
Today. All right. So you're gonna pay the 300 and then you're gonna get assistance that you think will take care of the whole thing?
Yes.
All right. So let me adjourn this out to June 27th, 2025 at 2 p.m. for you to, if all that comes through.
All right. Thank you.
All right. Thank you. Court does call the case of New Park Ridge Apartments versus Karina Jones. Ms. Jones?
Yes, I'm here. I'm
Okay,
trying
I'll
to do
need
my
it.
video and stuff.
What'd you
I'm here.
say?
I was trying to do my
Oh,
video.
no,
I'm
you
here.
got it. Okay.
Gina,
All right. Where are we on this case?
I have a balance including court cost of $1,901.
All right. And ma'am, how are you intending on getting that paid?
Right now I'm going through Hawk. I'm trying to see. I've checked in on my documentation, so I'm basically waiting on a response.
You're waiting on a response from Hawk?
Yes.
Okay. No, do you have any notes regarding that?
I do not, I'm sorry.
All right. Okay, ma'am, what I'll do, we'll give them time to see if there's going to be a response. I'll adjourn this to June 27th, 2025 at 2 p.m. Okay?
Thank you so much.
Thank you. Have a good weekend.
You too. Here.
Let's call the case of New Park Ridge Apartments versus Precious Terman.
Jillian Engen for plaintiff.
Yep. Somehow I knew Precious was in the house. Come on. Hello, what's your name?
Precious time.
All right. And what's the claim in this case?
I have a balance including court costs of $4,954.
All right. How are you intending on getting that?
Honestly, I feel like the whole process is a fluke because I'm low income
and my rent is really only like $180 or something like that. And they're charging me market rent because they said that my recertification wasn't complete in a timely manner, which it was supposed to be done in January. I have been here 8 years and never have I had that completed in January due to the lack of them telling me what paperwork to turn in. I'll turn in the paper, they'll come back and tell me I need another paper.
Have you spoken to legal services at all?
I have not.
I'll give you an opportunity to speak to legal services since you're indicating that it's
Yeah, 500 of this balance is coming from them trying to charge me for my security deposit, which again, I've been there 8 years.
okay. I don't know that. I don't have the ledger in front of me.
I have one.
But okay, that's not going to help me right now. So what I'm going to do is I want you to at least reach out to legal services, or actually president of the courtroom, and talk to them.
Okay.
I will adjourn this out to June 27th, 2025 at 2 p.m.
Okay.
All right. Thank you. Court does call the case of Peninsula Place Apartments versus Jacqueline Gardner. Gardner?
Yes, hi.
Hi, how you doing? I'll need a camera if you can.
Okay, one second.
All right, what's plaintiff's claim in this case?
I have a balance including court costs of $2,406.06.
Okay, $2,406.06.
Yes.
All right. And Ms. Gardner, how are you intending on getting that paid? You're muted.
Yes, sorry, I had the baby in my hand.
Okay.
I'm still working with family to get it paid off. I go back to work in like 2 weeks and a couple of days, and then I should be able to make some payments myself. But I'm not sure like if it can keep getting adjourned or not.
Okay.
From my maternity
but
leave.
you're talking. I remember because the maternity leave. I remember, and you don't qualify because you're on maternity leave, and yeah, that crazy system we have. So,
yeah.
All right.
Sorry, I'm holding the baby.
So you had your baby?
Yes, I'm holding him.
How old is he now?
He's 2 weeks, going on
That's
3.
what I thought.
Yeah.
Well, first of all, congratulations to you.
Thank you.
All right. What's the name?
Jace Jameer.
Jameer? All
Jace
right.
Jameer. Yep.
J. Jameer. Okay. Well, I know she's been working with family, and it was a no-win situation for her. So the court's going to adjourn this out 2 weeks to the 27th, 2025 at 2 p.m. We'll do that in honor of the baby. Okay?
Thank you so much. Thank you.
You're welcome. All right. We'll see you in a couple of weeks. You take care.
Okay. Thank you too.
Thank you. He didn't give you much. Provident Asset Management versus Sandra Moore. Here.
Here. I'm here.
Okay. Where are you? Okay, I'll need a camera. Where are we
Okay.
on this case?
I have a balance including court costs of $2,515.05. I think that there was we were trying to get an update from Hawk at the last hearing.
Right. Ms. Moore, have you heard anything from Hawk?
No, the only thing, yeah, I did. She said that she was reviewing my documents, but I sent them in 4 weeks ago.
Okay. Ms. Moore, here's what I'm going to do. I'm going to adjourn this out to the 27th, 2025 at 2 p.m. And let's see if what we can do is try to get an answer, good or bad. All right?
Okay. All right.
All right. Thank you.
All right. Thank you.
Court calls case People versus, or Faith Shepherd versus Decreta Thompson.
Yes, can you hear me?
Yes, who are you?
I am Lucreta Thompson. I am the defendant. I guess you I'm the defendant.
The defendant. Okay,
Yeah.
I'll need a camera.
All right, here I come right now. Oh gosh. Oh, wait a minute, how do I do this? How do I do my
This is a
camera?
termination?
Yes, it's not, it's so I have to get my camera on. Oh, that's weird.
Yeah.
This is a termination initiated by a notice to quit for a 1 month notice to quit for a month-to-month tenancy.
All right.
Okay.
All right, Ms. Thompson?
Hold on right now. I'm doing it right now. Yeah, can you see me now?
I now can see you. All right.
Okay.
This is a termination of tenancy. You had a month-to-month tenancy?
No, I have a 2-year lease, Your Honor. I've been living here for 7 years. I also have managed properties for the owners. Right now, my lease is up in 4 months. I just got a notice. I don't have a problem if she wants to retrieve her property. I mean, her property here, her residence is fine with me. But I only have 4 months left with my lease.
So hold on.
I need time.
Hold on. So you're saying it's a month to month?
No,
Yes,
it's
Your
I have a
Honor.
2-year
And
lease.
ma'am,
No.
ma'am, stop. Plaintiff is saying that it's a month to month. You're claiming that there's a lease. I
Yes.
don't have a copy of the lease. Do you have a copy of the lease?
No, actually, I don't. I gave it to the owner's daughter 2 years ago, and I haven't had it, sweetheart. No, I haven't. So, I mean, Your Honor, I don't have it. She has it. So it's never been a month to month. As long as I've been living here, never been a month to month. I've been living here for
How
7
long
years.
have you been living there?
7 years. And I also manage properties for the owners. There are other properties that they have.
All
So I
right,
was
so
maintaining.
here's what I'm gonna do, because that's certainly a dispute as to it. So I'm gonna set this for a non-jury trial, July 1, 2025 at 9 a.m. That's an in-person hearing, so you'll need to be here, ma'am. And they'll have to have somebody and show me either that there's no lease, or you'll have to show me that there's a lease, but then I'll make a decision on it, okay?
Okay. Also, I'm also leaking out legal help, legal representation.
All right, that's fine. You can have legal representation come with you on that date, but I'm gonna set it for trial on that date.
Thank you so very much. And you have a
Thank
beautiful
you.
day. Thank you so much.
You do the same. Sparrowwood Apartments versus Regina Agnew.
She's here, she stepped out.
Strong Future Homes versus Lolitha O'Day. Lolitha O'Day, where is she?
She's outside. She's talking to legal services.
Or pass it. Court calls the case Strong Future Homes versus Sajidra Moore. I got that right. Hello, your name?
My name is Ciatra Moore.
Ciatra Moore. Okay, I messed it up. Why are you laughing? Why are you laughing? Look at how it's spelled. I mean, it actually is spelled exactly as she said it. However, not where I would put I wouldn't break the name right that way. Anyway, all right. I apologize.
It's okay.
All right, what's the plaintiff's claim on this case?
I have a balance including court costs of $560.
All right. And ma'am, how are you intending on getting that paid?
If I can, I would like to pay it by the end of the month.
Okay. When you say by the end of the month, what day can you?
I can pay it by the 30th, but I get paid on the 25th, but I just want to give myself some grace.
All right. Well, okay. If you get paid on the 25th, can you get it paid by what time we set to? By say noon on the 27th?
Yes.
Can you get it paid by then?
Yes.
Because if you get it paid and they know, then the case can get dismissed.
Okay.
Okay.
That's fine.
So I'll adjourn it out to the 27th, 2025 at 2 p.m. You'll get that paid before noon.
Yes. And I have to come here. Can I pay online? I have to.
So you can't.
How you normally would pay.
You pay, yeah.
Okay.
And if you can pay it on the 26th, that would be even better.
Okay.
Yeah.
If possible, because then we'll just ledger.
Okay.
And hopefully it'll be dismissed and you don't have to show back up.
Okay.
And then I don't have to try to butcher your name. All right. All right.
Thank you.
Thank you. Thank you. Court calls case Strong Future Homes versus Jamie Kaiser.
Jillian Engen for plaintiff.
Good afternoon, Your Honor. Andrew Campbell on behalf of the defendant. Judge, today I filed an answer affirmative defenses in an appearance, and for the record, I'm personally handing a copy to opposing
Where was
counsel.
that filed?
That was filed
that today?
Yes, Your Honor.
That's right.
And Judge, I do request a week to file a counter complaint. There is a cause of action under the Regulation of Collection Practices Act because this debt's been paid already, and it's pursuant to a previous case that you signed a
Now,
condition.
if it's been paid, then why can't you just work that out?
Well, we can, but we
file what you want to file. June 27, 2025, 2 p.m.
Okay, I'll file that counter complaint within a week, Judge.
I'll do what you're going to do.
Thank you.
Court calls the case of Strong Future Homes versus Alana Lindsay.
Jillian Engen for plaintiff.
What's wrong, ma'am? Were you trying to get us our attention?
Yes, the culprit is Regina Agnew. I had to go to the restroom. You know, you make me so nervous.
Whoa. I made you nervous? No, oh, in a good way. Oh.
Let my neighbor that I'm sitting by know that if they call my name, I have to go to the restroom.
You know what? I knew it was you, so I waited for you to walk out, and then I called. No, I'm kidding. I'll call you back up momentarily, man. Strong Future Homes versus Lindsay. Your name?
Alana Lindsay.
All right. Where are we on this case?
Your Honor, I have a balance including court costs of $486.
All right. You were gonna get that paid. That's what you
Yeah.
told the court last time?
I just haven't got paid yet. The last court date was like last Friday, and I get paid every 2 weeks, so it just hasn't happened yet.
Okay. So when do you get paid?
Wednesday.
This upcoming Wednesday?
Yeah.
Okay. All right. So it said you're gonna pay it in full by next week, but maybe that, okay. But I wasn't the judge on the case. So here's what I'm gonna do. I'll adjourn it to June 27th, my next day, 2025 at 2 p.m. Okay? Get that paid. All right. And then you don't have to come back and see me, so I don't make you nervous.
Thank you.
You're welcome. I said it. Yeah, I said that for you. Strong Future Homes versus Charles Ellison.
Jillian Ingham for plaintiff.
Hello, what's your name, sir?
Charles Ellison.
All right, he's here. All right, just turn up. There you are. Okay. All right, where are we on this case?
Your Honor, we're requesting to adjourn to the next hearing date. My client's doing some recalculations on the ledger.
All right. You have any objection to that, sir?
No, sir.
Okay, didn't think you would. June 27th, 2025, 2 p.m. All right?
Thank you.
Thank you. Strong Future Homes versus Chanel McFarland.
Jillian Ingham for plaintiff.
Hello.
Hello, we meet again.
What's your name?
Chanel McFarland.
Thank you. All right, where are we on this?
Your Honor, I have a balance including court costs of $6,817. I understand that Ms. McFarland is contesting it. I think that I haven't been able to take a closer look at the ledger, so I can't speak to the claims on it. But we'll look at it and hopefully.
Go ahead, man. What did you want to tell me?
Well, I was in court, this last November for the same case. My son had passed away, so they dismissed the case. But my legal aid attorney that I had asked them to figure out how much was owed because I didn't owe them all of that. I did put in an answer form to the clerk. I have pictures of the repairs that needs to be done and the repairs that, excuse me, that I have done.
Okay, the legal service is going to represent you at this point, you know?
He's he's out the state this week. He did send me Alex Henry.
Okay, did he say he was going to represent you?
Yes.
Okay, let me do this then. June 27th, 2025, 2 p.m. Okay, get back in contact with Mr. Henry and let's try to get that sorted out where we're going to.
All right, thank you.
Thank you. Strong Future Homes versus Catrice Hadley.
Jillian Ingham for plaintiff.
Good afternoon, Your Honor.
Good afternoon. What's your name?
Shatrice Hadley.
All right. And what's the claim on this case?
I have a balance including court costs of $2,108.
All right. And the notes from last week said you were going to have it paid in full by next week.
Yes, so I have a check that I'm prepared to endorse to them today for $1,000, and my refund check is supposed to be deposited any minute now.
Refund from
school.
Where are you in school?
Henry Ford College.
I don't know then. All right. What are you studying?
Social work.
You got enough of those. All right. Okay. So you got your refund check coming in. You have $1,000 now.
Yes, sir.
Okay. But I don't know. They can't take a third party check probably.
Your Honor, I don't know what the negotiable instruments do anymore. I think probably since it's going to be adjourned for 2 weeks, Ms. Hadley, if you could maybe cash it or
That's fine.
Okay.
That's fine.
Yeah.
Then here's what I'll do. I'll adjourn it to June 27th, 2025 at 2 p.m.
That works for me.
If you get that $1,000 into them and then and your refund comes through, then you get it paid, then you don't need to be here then.
Yes, sir.
All right? Okay.
Works for me.
How are your grades?
Really good.
Really good? Okay.
I'm proud of myself.
You know, when
45 back in
you see
school.
the smile on their face? Oh, yeah.
I'm doing
Fantastic.
great. Thank you.
All right, you take care. Strong Future Homes versus Candace Long.
And for plaintiff, Your Honor, defendant Anthony Long was here earlier. He had to go to work. He says he's going to pay the balance in full on, I think it's Monday. Obviously that's within the 10-day period. I told him that I told him that I would ask the court for a judgment, but we would set it aside if paid in full on or before June 3rd, 2025.
All right. So what is the claim?
The balance rent for team session is $717. Court costs are $222 for a total of $939. The redemption date is June 23rd, 2025, and it will be set aside if paid in full on or before June 23rd, 2025.
All right. I'll issue a judgment for possession. I'll do it by default. Redemption amount in the amount requested with the writ issue in 10 days. That will be set aside if it's paid. All right. That one. Go back to these. Nope. What'd you say?
Okay.
Let's see who I want to call. Let me call this one. Strong Future Homes versus O'Day.
Jillian Ing and Katrina.
See, I'm making late.
Good afternoon, Judge Simpson.
Good afternoon. What's your name?
I'm Malik O'Day.
All right. And what's the claim in this case?
I have a balance including court costs of $909.67.
All right. So Day, how are you gonna get that paid?
I talked to Hawk and I'm waiting on my SER, but I was just at court, it's $800 and some dollars. Like, I don't know. This is from
It looks like a late fee might have been added.
This is from 2023, Your Honor.
Okay.
I mean, I don't know. They never told me nothing until now that I owed this back money. And I just got
Okay,
the
do you
bucket to
think you
legal
don't
aid.
know it? Or
I don't know. I can't even remember what I ate in March of 2023, Your Honor.
what you ate in March of 20?
I don't know.
If you can even remember that far back. Because what was this morning? What did I eat this morning? See, that's as far back as I can go.
That's why I'm in court for 2023. I don't know. I just got my ledger from Tanisha. I got all my papers.
So did you want somebody to help you go through that? Did you want to talk to legal services
Yes.
about going through that?
Yes, sir.
All right. So here's what I'll do. Let me adjourn it June 27th, 2025 at 2 p.m. That'd be an in-person hearing. Get with them, go through the ledger. Let's try to figure it out.
Okay. You said June
27th.
At what
That's at
time?
2 p.m.
2 p.m. Thank you, Judge Simpson.
You're welcome. Okay, you take care.
I'm at.
What did you say?
Thank you.
What'd you say?
I said I will. I will take care of it.
Okay. You have a great weekend.
Yes.
All right. Did I make you nervous?
Still true. Yes.
Wow. Wow. Oh. You did not have to sign on to what you were saying.
When a person ain't never been through none of this, you know, I watch you a lot, and you're very, very, very fair, and I love that.
Thank
But
you.
I don't know, just shake.
No, I got you. Thank you for saying that. I appreciate that. Turn around and tell her that. Sparrowwood Apartments versus Regina Agnew.
Jillian Ing.
I was gonna make her wait to the end.
I thank you. God is good. I thank you because I want to go to work. I said, Lord, if you let me be out of here by 1:30, I don't have to call off because I need the money.
You are just gonna hold church up in here. All right. What's your name?
Regina Agnew.
All right. Thank you. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $1,504.90.
All right. Ms. Agnew, how are you intending to get it?
I talked to Robert G earlier, this morning about Tennis, and I went on the portal because he straightened some things out for me where I can go in, and I paid $200.90, which came out to $206.91 because of 2.99%. That's a lot.
Okay.
Money. $6 is a lot in this economy. But anywho, to make that payment, I had stated to him that on the 20th, I would make a payment again, and I will be all paid up by the 27th. Oh. So on next Friday, I will make a payment of $550 and the remainder on the 27th. Right. Now, what I would like to say is, I understand business is business and they need their money. When I moved in the end of March, six days before the end of March, my door is, how would you say? I would say jimmied by the maintenance person, the sliding door, where if someone really wanted to get in my home, they could. And if I could just put it in escrow so they know that, okay, I know it's business, you're bringing me to court. Yes, I owe you this. Yes, I do. But please make sure that my living quarters are good per the state guidelines as well, because they told me that it would take, the guy that came out and measured the door. You can. The gentleman that came out and measured the door said that they had been telling them, Empire Management, with the prior tenants that lived in that particular unit that I'm in now, that they would need to replace the door. And the door has not been replaced yet. And today is, June 13th. Thank God I'm not superstitious. And it has not been replaced. So to be fair,
you need the door replaced.
I need that door replaced. I haven't been holding funds because of that. It's just other things that's been going on. And I just returned back to work on this past Tuesday due to
what do you do for a living?
I'm in the auto industry, 26 years. Auto industry. Yeah, I know they say, oh, why she in court? To all the
no, I didn't.
Not you, Your Honor, but to all the living, because there's some people out here that watch this landlord tenant stuff that don't work and they just want to, such and such was in court because they owe for this, but it's real out here. And mental health is real. I have lost people, but I'm saying this for the viewers too.
Oh, so now you're going to talk. Go ahead, girl. I cannot stop you. Just go ahead. I figured she wasn't talking to me, so go ahead.
No, you're good. You're right here. You're right here with me. You're right here with me. You just make me nervous. Well, I have to keep going back to the bathroom while I tell my neighbor. If they call my name, please tell them I just went to the restroom. But I haven't been holding money due to what they owe, but they're coming down hard on me. So since we're going to be hard about it, please take care. You shouldn't even okay for me to move in when I did and things was not taken care of. That's all. That's all I'm saying. But I will have this satisfied by the 27th, and I look forward to seeing you. If I have to come back in here in court, I hope not, because my shift started at 2:30, and I don't have to call in because God is good, because I'll be out of here. But we as people,
you just let me know when you're finished.
So we as people in the auto industry, we go through things too. I just want the viewers to know. Yes, I thank God for my employment. I was able to raise my children up on it, but there is things that goes on in life.
Okay, all right.
Thank you, Your Honor. I appreciate you.
And I you. Did you want to say anything, Miss?
Your Honor, I don't know if I can follow that up. Is it the latch? It's just not latching?
It's what it is it's the sliding door, and so you have the door that latch, but the back side of it is a gap. Rodents can get in, so they put cardboard in it.
I see.
And they told me they ordered the door, it would take 6 weeks. So we're 6+ weeks out. And I just need communications, everything, like they tell me, and I agree.
Thank you.
But I'm not holding rent because of that. But since we're in here, let's have a conversation about it. Respectfully.
Okay, did you want, you mentioned, I almost don't want to.
Escrow.
You want to put it in court escrow?
And I do.
All right, so you need
next Friday, I will come to the courthouse and I will put that $550 in, and the following Friday on the 27th, I will pay the remainder. And I tell you, Your Honor, you will not see me out of good faith in July, because July will be on time.
Thank you, ma'am.
You're welcome.
All right.
I appreciate you. I do.
June 27th, 2025, 2 p.m. All right.
Okay, thank you.
You take care, and they'll make sure to get you do. Really? Oh my God. I'm tired now. Flomar Apartments versus Duford recall.
Jillian Aiken for plaintiff.
Were they here?
I thought he was.
Okay. This is a recall on the case. They're not here. If you'd like to take a default, you may.
Your Honor, actually, I would like to request leave to amend. We have a 1 month split, and I just want to.
Leave to amend. You're amending it to a termination action.
We'll probably include both counts.
Gotcha. All right. Leave to amend is granted. And I will then adjourn this out, give you time for service to June 27th, 2025.
Thank you, Your Honor.
At 2 p.m. Thank you. That's it for that block. Let's get the video going. I'll come back. Court standing recess. Everybody can remain seated.
All right, I'm gonna get the 2 o'clock, I'm sorry, the 1 o'clock people check yes, call your name, speak up for me. Sadie Armstrong, are you here? Sade, yes. Sade? Yes, thank you. I'm so sorry. Jordan Oren, are you here? Yes. Thank you. Angela Schmidt. Edward Woods, I'm in Zoom. Quantavia Sandrit or Christopher May. Michelle Kresnick, I see you in Zoom. Amy Wisner, here. Thank you. Tamara Hopkins, I have you. Katie Campbell Little, are you here? Thank you. Derek Wanchon or Elizabeth Wanchon? Thank you. Samuel Bishop. Stephen Shelton. Brandon Kutcher, I see you in Zoom. And Leo Stringa. Okay.
District Court from County Washington, State of Michigan is now at session. The Honorable Judge Jay Sedgwick.
You may be seated. Court does call the case. Jeff Lewis versus Michelle Kresnak.
Both Jeff and Julie Lewis are here. They just temporarily stepped out. If you'd pass it for a few minutes until they return. Thank
Couple
you.
minutes, sure. They're coming in now. All right. Go ahead. We'll go ahead on it.
Daryl Barton appearing on behalf of Jeff and Julie Lewis.
Michelle Kresnak?
I am here.
All right. Okay, this is a termination of tenancy case. And basis for the termination?
They have violated the lease. They have not made any payments since February, and the outstanding balance is $9,851.15.
But there's a lease covering the premises.
That's correct. We'd like to ask to, if need be, leave to amend the complaint to include Noah Rush, who apparently has been living there the whole time, and is just the electricity was, he claims to be the main tenant. The electricity was cut off.
Okay, so, well, we got a problem here. And the problem relates to the notice to quit. Because the notice to quit is to terminate the tenancy, but the claim that you have is basically a rent claim.
It's actually including in the lease. We asked that we had a supplemental judgment on that, but the lease, well, my glasses here.
I don't think that you can do that though.
Okay.
If the claim is for not paying rent, then one would have to file a non-payment of rent.
It says under the lease, the lessee agrees that the lease agrees that the lessee's failure or refusal to perform according to the terms of this lease agreement will allow the lessor's option to terminate this lease and begin eviction proceedings. That's specifically in the lease.
I don't doubt that. But it can't be terminated like that. It just, there are two separate sort of avenues. One being a non-payment of rent, one for others, non-payment of rent and termination of tenancy as a whole without the option to redeem. When it's a non-payment of rent, part of the remedial measures is that the tenant has the ability to redeem. And so I don't know that I can do much with this case. Because along the lines that you're asking me to terminate.
File a 7-day notice to quit.
That's what's going to have to end up happening. I don't think, based upon this, that the court has subject matter jurisdiction over the case for the reasons that you stated. So, and when that happens, the only remedy I have is to dismiss the case. So I'll dismiss this case for lack of subject matter jurisdiction, and then we'll await your arrival back here. And with reference to that other issue, did you see Miss Widely? We figured it out on the
other case.
The other thing that talking about the execution.
Yeah.
Okay.
Is there something I need to see her about?
Pardon?
Is there something I need to see?
Yeah. If you talk to Ann, she'll update you on what we found out. Barnes and Barnes versus Cotavious Scandrett.
Philip Friedman for the plaintiff, Your Honor.
And also Christopher Mayo.
Mr. Mayo made representations the last time that he was going to get us paid fully.
Yes. And has not.
He's not. And he's not here, and so I'm going to raise my right.
You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth. Okay.
I do.
Go ahead, sir.
We checked the ledger as recently as about 45 minutes ago, and the number is for rent is $2,335.34. That's 2335.34. $250 in costs for 2585.34.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
And if he pays it within the 10 days, I'll set it aside.
Set it aside. All right.
Thank you, Your Honor.
Thank you, sir. Ridgewood Apartments versus Amy Wisman.
Good afternoon, Your Honor. Mark Swessinger appearing on behalf of plaintiff.
Hello.
Hello,
Your name?
Amy Weisner.
Okay. And how much is owing on this currently?
Judge, with court cost, there is presently $5,460.87.
And how are we going to get that taken care of?
I'm still waiting to hear back from SER.
I talked with Hawk and they are out of funds right now, but they have me on their list. And I'm working with family to try to secure anything and still interviewing for jobs. I lost my job in December. I lost all my income source in December, right when I moved in. So.
All right. So the problem that we're going to have here is I've given the adjournment for the filing of at least a claim that you're seeking assistance.
Mhm.
I don't have anything. There's not a dispute at all as to what's owed. So what I'm going to do is I'm going to issue a judgment finding no tribal issue in your hearing. I'll issue a judgment for possession and money in the amount paid for $5,460.87. What I will do, since you're waiting on Hawk and I'm not sure where they are, the normal writ date would be the 23rd. I counsel over the objection of plaintiff. There's no writ until the 30th.
Yeah, the week
Judge,
ends
why
on the
would-
29th. So.
Judge, why would you assume I would have objected?
You're right. I didn't, but in case you did, I was taking a preemptive step.
Thank you, Your Honor.
Thank you. Thank you.
Judge, we'll submit that.
All right.
Bye-bye.
Bye-bye. Northfield Estates versus Tamara Coppin.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Hello, your name?
Tamara Copens.
Tamara Coppins. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Well, Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
All right. And ma'am, what's your basis for setting aside the judgment?
I took a fall on their property and busted my kneecap in half. That was February 2nd, and I lost my job, a great job. I had just been approved. I worked for the Veterans Affairs, and I'm not quite sure I know what set aside means. I have tried to make payment arrangements with them. In fact, I even tried to make some payments, but I'm blocked to make them. And
Let me stop you there.
Sure.
This is a motion to set aside the judgment which you filed.
Okay.
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or bond wasn't paid on this, but that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense of their claim for rent. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
yes, I can.
Okay, so why?
I went to the courthouse, and it was closed in Saline. I'm on the summons, which I've never had before. It said appear to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, "Nope, you're evicted." And I'm like, "What?" And then I wrote a letter, and then the lady I was working with said, "You got to fill this out." I filled that out, and I had no problem paying some money to an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them. I mean, I didn't have to lose my job and fall, and so they should work with me.
Ma'am, so let's assume I take that as a good cause. You're not disputing that you owe the amount.
I am disputing it in the sense that they should negotiate with me because I lost my job because of their
Negotiate
mistake.
In what sense?
Negotiate that I don't have to pay the rent or pay some of it until I get back to work. And then the whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault. I
understand what you're saying, but I've given them all my medical records. They know that's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them to.
There's probably more owing now.
Oh, I'm sure that there is.
And Your
How
Honor,
much is owing?
the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Copens has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations. But there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent, which she has not done. And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out and I made my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what notarious means. I don't think there's any doubt in Northfield Estates, but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a job at the NSPA.
Okay.
So why can I not make a payment schedule, like $1,000?
That's going to be something that has to be negotiated between the parties.
That's what I tried to do.
Okay. But if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right. But they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years, and it's been paid every month because I didn't prove that there was a good cause. I didn't go to court. I'm confused.
Asking the court to do something the court can't do.
Which is what?
I can't force them to enter into a payment plan.
Okay.
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning, two things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
And both,
frankly,
I've done one of those.
You have to show me both of those, and neither of those have you shown me.
I did.
We had gotten a call, and it sometimes does happen. I'm not going to dispute that somebody goes to the wrong courthouse. We get a call, we get something.
You did
that day.
You did
saying, "Ma'am, I don't have a record of that."
I sent it to the court, and you emailed me back.
Ma'am, don't overtalk me.
Sorry.
I'll let you go on. I'll let you tell me anything, but you're going to have to stop over talking.
Okay.
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent claim. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what? How much does she want?
It would be $29,0218, but if you pay $22,3479, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge Simpson has set this aside. You're going to go the 13th. So you're telling me to show you something that
told you that.
I have my phone. I have your emails. I have it from your courthouse. Not being directly.
I can.
She's been copied.
I've seen the email chain, and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge Simpson has granted your motion to set aside default. The motion hearing is set or scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence. I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion. The civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13/25 at 1 p.m. And I said, so the motion is granted, is not granted, just set for a hearing. If so, that may need to be clarified with the tenant, because I believe that Ms. Copens was under the belief that the judgment had been set aside, not that a motion had been granted or a motion hearing had been granted. I did correspond with Ms. Copens after that and explained to her that no, per my communications with the civil clerk, a motion hearing had been granted only, not that the judgment had been set aside, and that the hearing that was scheduled for today would be before Your Honor to determine if the judgment should be set aside or if the judgment would stand. Ms. Copens responded something along the lines of, I don't understand, I don't know the legalese. I'm going to take it to mean the judgment was set aside.
Ms. Dornbush, were you reading, did they indicate initially that the judgment had been set aside?
The email to Ms. Copens does say the judge has granted your motion and set a motion hearing. So it's a little ambiguous, Your Honor. The document that I believe was provided to Ms. Copens, and I'm looking for the notice to appear, it doesn't indicate hearing for non-payment of rent. It indicates motion hearing. And I'm looking for the attachment.
I'm looking at it now, actually. I'm looking at our notice that we're gonna. All right. All right. So you're having the hearing at this point, ma'am. I have not ruled on it at this very moment. However, I'm telling you, I need two things. And the first thing being that there has to be a meritorious defense. Second thing being, and as I'll just tell you, neither one has been shown to me. So the motion to set aside the default is denied. The judgment will stand. And
so you're saying that they can evict me?
Ma'am, what I'm saying is,
I honestly don't understand.
Okay, then I'll tell you this. The judgment that was entered on May 23rd will stand. And in that judgment, if you read the judgment, you have a certain time in which to pay those funds. As I indicated, that amount was $2,234.79.
Okay.
If that is not paid, then the landlord can seek their remedy, which would be an order of eviction, indicating that nothing has been paid on this, and then have you removed from the premises. Yes.
Okay, I have one more question. You were not going retrospective back that I had to pay it by the 23rd of that month. I can pay it today. Is that correct?
Do you have it today?
I can't. I will get it. I've got family and friends. I just wasn't going to get 1,000.
If you get it paid, they would need to, the way this court has ruled, they would need to accept it. So.
Is there an appeal? Because is there a way to appeal? And I'm saying that only because I was sent something
Ma'am, ma'am, I cannot give you legal advice. If you want to get legal advice on your rights,
I would like to do that.
Then you can go and do that. But my order that your motion is denied stands. Motion denied. Thank you.
Well, I guess you're welcome. All right.
Court calls the case of River Ridge versus Kaylee Hamill Little. Hello.
Hi.
What's your name?
Kaylee Hamill. It's no longer Hamill Little.
Divorce?
Yes, thankfully.
Don't smile. No, just don't smile. Okay, fine. All right. Okay, what is the claim at this point in this case?
No, Your Honor, $1,748.
All right. And how are you intending on getting that paid?
So I have a couple questions because there were court fees from the last time that were added on after every payment was made. Like we were here March, I think it was.
Okay.
And everything was paid up, and then they added court fees on the following month and then denied a payment. It was really weird. So I called, spoke with management about it. There's no longer a manager at that location, so they had to call who's ever overseeing it. And then it took days to get back. So I was very confused. And when they explained it to me, it didn't exactly make sense. So my ledger didn't add up, and I'd already paid April's rent. So that ended up showing up late. It was a whole fiasco. And all in that time, I lost my job because of nursing school. So I've been fighting with unemployment.
Got it.
So I literally just had like a court hearing judgment, something along those, I don't know the technical term, yesterday that was canceled because my old job stopped protest. I'm not sure.
So are you telling me you can't pay this amount? I'm sorry, Ms. Dornbush, you were going to say something.
Your Honor, yes. At the last court date, Ms. Hamilton raised these issues, and Judge Barr advised her to either call management or to call me to discuss. I don't know if she spoke with management or if her conversation with management took place, that she referenced took place before or after the last court date. Your Honor, I can tell you that my client has credited court costs of $174 that were assessed in April. I believe my client's intention was to file suit in April. And it looks like they did not. So they have credited those court costs. Ms. Hamel is though responsible for the court costs associated with this filing that occurred in May. So the
Got it.
$1,747 does take into account that $174 credit.
Yes, and that makes sense because the total figure given at the June 6th hearing was 1922. So
Okay.
they credited it.
Okay, so I can make a payment coming up Friday of 300. But like I said, I'm waiting on unemployment. I don't.
When do you think your unemployment's gonna hit and then they're gonna have a retro check to you? You don't know.
You're more acquainted with the state of Michigan than I am when it comes to that.
Probably not, but
I also am
go ahead.
in the process of the hiring at another hospital that is working with school schedules. So,
all right, here's what I'm going to do. There's not a tribal issue. I'm going to grant a judgment after a hearing on this matter for that amount of the 1748. What I will do, because they can't wait on that, so you can pay the 300 to them. That's at least going to reduce your balance. Okay, and then if you get to your unemployment in any retro, then you'll be able to do that. Yes. I will have a writ to issue. It would normally issue on the 23rd over the objection of plaintiff if she's waiting on unemployment and I get it. I will go to the 30th. I'll give her an additional week because if she gets her unemployment, then it's going to be getting them to send that other check. So
right.
You get that. So, all right.
Okay.
That's over plaintiff's objection.
Thank you.
Okay.
So I have until the 30th.
You have until the 30th,
Perfect.
but get the 300
next
right away. Okay. But that gives you a little bit of provision.
Okay.
All right. Thank you. Sile Farms versus Derek Wanshan and Elizabeth Wanshan. Hello.
Hi.
What's your name?
Elizabeth Watson.
Wanshan. Okay. And what is plaintiff's claim in this case? This is also yes, go ahead.
$29.05 and 46 cents.
905.46. All right. And ma'am, how are you intending on getting that paid?
I wanted to ask today if we could pay this full balance at the end of the month, the 27th.
Will you have it by the 27th?
Yes.
All right. So here's what I'll do. No tribal issue after a hearing. I'm going to grant a judgment for possession. Okay.
Okay.
In that 2905.46. You say you'll have it the 27th?
Yeah.
Normal writ date will be the 23rd. I'll indicate no writ till the 27th.
Okay.
That'll give you time to get it paid.
All right.
All right. Thank you. Spice Tree Apartments versus Samuel Bishop. Samuel Bishop. There is no response. You had previously been sworn. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,584.74, cost of $169 for a total due of $3,753.74. We're asking for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount any amount requested, writ issue in 10 days. Spice Tree Apartments versus Stephen Shelton.
Yes, I'm here.
Your name, sir?
Stephen Shelton.
All right, you got it. All right. That's not a phone, is it? I'll need a camera if you can get that. But what is plaintiff's claim?
Rent to retain, I'm sorry, Your Honor, the total with court costs is $2,921.69.
All right. Mr. Shelton, how are you intending on getting that paid?
I'm making a payment later today, and then I'm gonna pay the rest next Friday. So by next Friday, it should be all paid.
So by the 20th?
Yes, correct.
All right. So here's what I'm going to do. I'm going to find no tribal issue after hearing. I'll grant a judgment for possession in the full amount of $29,21.69, and that is to be paid by the 23rd, that Monday after that. Okay, so that's your statutory period, but if you get it paid by the 20th, you'll be good. Okay.
Okay, sounds good. Thank you.
Thank you.
All right.
Valley Ranch versus Brandon Kuchar.
Brandon Kutcher, hi.
All right. Hello. All right. What is plaintiff's claim?
With costs, Your Honor, $4,676.45.
I'm sorry. Give me that number again.
46.76.45.
45. All right, sir. How are you intending on getting that paid?
We were trying to get it paid by Wednesday of 2 days ago. We were unable, but we'll be able to make payment in full through the rent payment portal online this weekend. We want to get it paid before Monday. I think then that adds another $100 on Monday. So we'll submit it before Sunday evening.
In any event, you'll have it paid before the 23rd, correct?
Yeah, absolutely. If you have to issue the the judgment and then it can be set aside. That's fine. We've had to go through this before. We will have it paid in full before the 26th.
All right, judgment to the, I'm gonna find no tribal issue after a hearing. There's no dispute as to the amount. Granted judgment for possession with a writ date of the 23rd. And then get it paid, you'll be all set and you can negotiate to set aside. All right? Okay,
Thank you very
sir.
much, Mr. Ornbush.
All right. And I think, is that it for you, Ms. Ornbush?
It is indeed, Your Honor.
All right, you have a great weekend.
Thank you, you too.
All right.
Bye-bye.
Arbor Club versus Sadie, is it Kayo Amphiphon?
Sade Kayu Ashampong. How are you today?
I'm doing well. How are you?
I'm well today.
All right. And Mr. Katz, what is plaintiff's claim in this case?
Good afternoon, Your Honor. Sidney Katz on behalf of plaintiff. There's currently a balance due, including costs totaling $2,994.2994.
Ma'am, how are you intending on getting that?
I'm currently waiting for a check to clear, so Monday or Tuesday when it's going to be paid in full.
It'll be paid in full. So certainly by the 20th, you'll have it paid in full.
Most definitely, yes.
All right. I can do it one of two ways. I can grant you the judgment at this point, counsel, or I can grant it out to the 27th. Which would you prefer?
You know what, Your Honor? I'd rather not have to come back if we don't have to. Usually I'd say I'm just getting killed with these court dates, Your Honor.
I hear you. Me too.
So if we could just do a judgment and
all right.
you know.
And then if it's paid, would you agree to set it aside for her?
If she requests a set aside and lets me know, I will do it.
Okay.
Yes.
We'll do it that way. No, finding no tribal issue after a hearing. Judgment to the plaintiff in the amount requested of the $29.94 even. All right.
Great. Thank you so much.
Writ date the 23rd. So get that paid and then you'll be all set.
Yes. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case of Six Trails versus Jordan Oren.
Good afternoon again, Your Honor. Sidney Katz on behalf of plaintiff.
That was nice of you to say close enough. But butchering names all day. Your name?
Jordan Oren.
All right. Well, I said it kind of close.
Yeah, it's close.
All right. All right. What is plaintiff's claim in this case?
Balance including costs totals 3,117. 3,000.
All right, sir. How are you going to get that paid?
So my dad is willing to help with a significant portion, and I actually just started work again at the start of this month. So I will get paid on the 26th of June, and mixed with what my dad is willing to help with, it should be able to cover the full cost by the
27th, 27th, just to give him a little cushion.
Sure.
All right. So no tribal issue after a hearing. I'll grant a judgment to the plaintiff in the total amount of the 3,117 and writ date 27th. All right, June 27th. All right.
Okay. Sounds good. Thank you, Your Honor.
Thank you. Court calls the case Willow Ridge Apartments versus Angela Schmidt.
Good afternoon again, Your Honor. Sidney Katz on behalf of plaintiff. I think there she is. She's on Zoom.
There she is. Ms. Schmidt.
Hello.
Hello. All right. What is the plaintiff's claim?
Balance including costs 4,311, $4,311.
Ms. Schmidt, when are you going to get that paid?
I was supposed to make a payment by today for $1,000. I tried to go online to make that payment and it wouldn't let me. So I was going to drop it off at the front office, but I wanted to make sure that that was where I should drop it off at prior to me doing so. So I have the $1,000. I was just waiting to find out what my step is supposed to be. And then the remaining balance by the end of the month.
No, 27th. That'll take it pretty much till the 30th at that point.
Yeah.
27th is fine.
All right. A grant judgment to the plaintiff finding no tribal issue after a hearing for the amount of the 4,311 and writ the 27th.
All right.
All right.
And then
thank you. Yes, ma'am.
The $1,000, do I just drop it off at the front office then, since I can't do it online? It won't let me do it online?
Whenever, however you pay it, you just have to pay the full amount by the 27th. There's no requirements of any specific amounts by any date. As long as you pay the full amount by the 27th, you're good. Right?
Yeah, no, she's trying to figure out where she takes it because I think the portal's probably shut off for her.
Yeah, the portal's shut off. You probably have to find out when the office is open and drop it off there. Give them a call. Just make sure. Okay.
Okay. And I'm sorry, can I have the total one more time?
4,311, $4,311.
Okay. All right. Thank you so much. Have a good
Thank
weekend,
you.
guys.
Have a good weekend. Willow Ridge Apartments versus Woods Edward.
Edward here, sir.
Is it Edward Woods?
Edward Woods, yes.
Okay, I don't know.
I don't know. We keep on doing it this way, Your Honor. I have no idea. This is the only one. It's like the third time I've seen.
Yeah, that's what's on the documents
I
too.
know.
Okay.
It's coming
Edward
from us.
Woods. Okay.
Your Honor, we did submit a proposed consent judgment to the court last week.
Yes. All right. And Mr. Woods,
I'm here, sir.
you signed the consent judgment indicating that you're going to pay a total amount of $5,030. Is
Yes,
that
sir.
correct?
Yes.
By the 27th. Do you have
Yes.
any other questions regarding anything on the judgment?
No, sir.
All right. Then I will enter that judgment. Sir, I do have to advise you have 3 business days to think about this judgment. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within that time frame. Doesn't mean that I would grant it, but you'd have that time to think about that judgment. You understand that, sir?
Yes, sir.
All righty. Thank you.
Thank you.
Thank you, Your Honor.
Bye, folks.
Have a good weekend. Your Honor, I was
All
ready.
right. You do the same, sir.
I was ready for that last woman at the 1 o'clock docket or the 12 o'clock docket. I think you need like an MC to call your next cases. It sounded like you were one of the TV judges. Next time, Judge Simpson.
You might be right.
Have a good day.
All right. Thank you, sir. Cheryl Barksdale versus Leo Stringa.
Good morning, or good afternoon.
Good afternoon. Who do I have here?
I'm Sherelle Barksdale, my husband Marlon Barksdale.
You just brought him along. He just straggled. All right. This is a termination of tenancy case. I don't have the defendant here. The defendant in custody. All right. There's no requirement that we bring them up. All right. Got it. And you were before Judge Barr. He disclosed that he had previously represented you, I think, on something. It doesn't matter. All right. And this is a termination of tenancy and there was a month-to-month lease. Is that correct?
No, it's a year lease.
Okay.
Lease violation.
Let's see. And then the notice. What are you claiming is the lease violation?
So in his lease, there is, in section R, harassment, annoyance, and, of tenants. So I'm getting complaints every week about him.
Gotcha.
And then also, in the lease.
I'm gonna have to stop you, okay? I'm looking at your notice to quit. Everything else looks like it was done correctly. The notice to quit, however, was not done correctly. That's what gives the court jurisdiction to issue a judgment for you. All right. And I can tell you specifically what's an error on it. And that is that, I don't know, do you have a copy of your notice to quit in front of you?
I have the summons and,
You go back, because you filed the notice to quit. Right?
Yes.
Well, anyway, at the very top, it says that your landlord is seeking to recover possession of property pursuant to, and then there are 2 check boxes. You have to put information as to why you're terminating it. So the second checkbox, which is the other, would be what you'd be describing to me. But, and I usually don't go through this with people, but you have to do that because they have to have notice as to why you're doing it.
Okay.
Follow me? Okay. And so since you haven't, I hate doing this, but since you haven't filed a proper notice, I don't have jurisdiction to do anything except dismiss the case. Okay. So that's what I'll do, right? Because I got subject matter jurisdiction, and I will dismiss this case. All right. Hold on one second. All right. And that's the last case that I have.
Yes.
All right. Thank you, Amy.
Thank you, Your Honor.